Morning, Judge Grosshans. You're on mute. All right, counsel, good morning and welcome to a Zoom oral argument session of the 5th District Court of Appeal. I'm Judge Rick Orfinger, and I'm joined on the panel today by Judge John Harris and Judge Jamie Grosshans. As you know, we're being broadcast on YouTube. So, and this is being recorded and will be archived on our website. Both sides have 20 minutes per side. Can you both see the clock on your screens?
Yes.
Yeah, sure.
Okay, great. If the appellant wants to reserve some time, I think the clock is set at 5 minutes. If you want something other than that, let us know and we'll try to adjust it accordingly.
5 minutes is fine for the appellant. Thank you.
Great. All right. Well, with that, we'll go ahead and start the case of University of Central Florida versus Boston Culinary Group.
Thank you. Good morning. May it please the court. I am Michael Crosby with the law firm of Shucks and Bowen in Orlando, and we represent the University of Central Florida. This matter relates to a protest of an invitation to negotiate regarding concession contracts for various locations on the UCF campus. More particularly, this relates to what purports to be a fee award, a final fee award from the quasi-judicial officer against UCF and in favor of the appellee, Centerplate. Now, the protest proceeding was governed by the Board of Governors Regulation 18.002. I may refer to that as the BOG regulations as shorthand. And what I'd like to do now is talk about 3 points from our briefing papers. The first is the quasi-judicial officer's lack of authority to enter a final award.
Let me ask you a question about that. There was a cert petition filed in the circuit court that challenged the president's authority to quash that order, and UCF lost that. Why doesn't that preclude you from litigating essentially the same issue again?
Well, it was very narrowly tailored. That's that 7-page opinion. And it didn't take into account the fact that there is no point of entry for a party to appeal a fee award under the way that it was, the way the fee was awarded. And that's subsection 22 of the BOG regulation 18.002. Under that provision, it would read alone, as Centerplate and the quasi-judicial officer insisted, there's no way for a party, be it a university, a protester, or an intervener, to appeal that. And so this is UCF's only point of entry to challenge what we firmly believe was an improper final fee award.
Okay, well, we'll ask Centerplate to comment on that when they get up as well.
Continuing on, the second point is the failure to properly apply Board of Governor Regulation 18.002 subsection 22, which is the fee provision. And third, and alternatively, the constitutionality of that subsection 22. So as to the first point, lack of authority. BOG Regulation 18.002 does not vest the quasi-judicial officer with authority to enter any final orders. Subsection 13, which concerns the quasi-judicial hearing, authorizes the quasi-judicial officer to issue a recommended order. Subsection 22 doesn't even authorize that. The regulations are clear that the president of the university issues the final order.
Well, let me ask you though, but the exact wording of subsection 22 is the quasi-judicial officer may award attorney's fees and costs to the prevailing party as appropriate. I mean, that language seems pretty clear to me that the ALJ, I'll just call him the ALJ, it says may award. I mean, it doesn't say anything else. What does that wording mean to you?
Well, what it means to me is that as part of a recommended order, an ALJ or an attorney practicing 5 years could award attorney fees, and that would be subject to a then preliminary order and final order by the university. And you picked up on that section 22. You'll note in section 22, and I'm looking at the BOG regulations now, if you look at that in a vacuum, there is no point of entry for a litigant to challenge a fee award. If you just look at section 22, if the tables have been turned and Centerplate had a fee award against it, if you only look at 22, they'd have no path to relief. So what the court needs to do is look at section 22 in connection with section 13.
Wouldn't the Administrative Procedures Act, wouldn't chapter 120 give them a point of entry, like the appeal of any final order?
Well, that's the problem. This is not, UCF is not an agency. And this proceeding, although the ALJ, the quasi-judicial officer, has sort of merged chapter 120 with the BOG regulations, there's no provision under chapter 120 for a proceeding regarding a bid protest involving UCF.
So let me see though. I mean, you said that UCF isn't an agency for purposes of chapter 120.
It is not.
Why is that?
It is in the definition of agencies, it is excluded to the extent it gets its authority from the constitutional mandate establishing the Board of Governors as part of the university system. It would be considered an agency if it derived power, authority from the legislature. But we're not here talking about legislative authority. We're talking about the Board of Governor regulations, which were rendered to the statewide university system by the amendment to Article 9 of the Constitution in 2002. So, but my point is, though, that if you look at subsection 22, you also have to look at subsection 13. And subsection 13 of the BOG regulations sets out the process for a quasi-judicial hearing. And it concludes, subsection K, part 3 says the president's final order is the final decision of the university. And then it goes on in section L to talk about a point of entry. So let me lay out a couple of scenarios. If the ALJ had issued a recommended order that included a fee award against UCF, UCF would have been able to accept, reject, or modify the fee award in the final order signed by the president of the university. If the university rejected the fee award, the party to whom fees were awarded would have a point of entry, and that is in the circuit court, the Ninth Circuit here in Orange County. If, on the other hand, a fee had been awarded against a party or an intervener, the same path for relief would have existed. So you can't read subsection 22 without reference to 13. And it just happens that 13 talks about the procedure, but 14, 15, 16, 17, 18, 19 all talk about things that happen in connection with subsection 13. Motions, evidence, extensions of time, the record. All of those are to be read in connection with subsection 13. That's how the quasi-judicial hearing is to proceed. So our position is the ALJ didn't have authority to enter a final award. And he didn't have authority because there's no provision in the bog regulations that gives him authority to enter a final award. The only power that he's given is to enter a recommended award. So that was issue one. Moving on to issue two, the quasi-judicial officer misapplied two terms from subsection 22. Non-prevailing party and improper purpose. Now, although UCF is not an agency, the language of subsection 22 is very similar to Florida statute section 120.595. And that employs the term non-prevailing adverse party and defines it as a party that has failed to substantially change the outcome of the proposed or final agency action, which is the subject of the proceeding. Now, subsection 22 omits the word adverse, but it's superfluous in any event. Given that the fee provision and the statute, the language is so similar, and given that there's no case that we could find interpreting subsection 22 of the bog regulations, we believe the court should look at cases interpreting 120.595 for guidance. And we found one, Johnson versus Department of Corrections. In that case, Mr. Johnson prevailed against the department in an employment action, and he sought attorney fees. But the first district declined to read 125.95 as a strict prevailing party fee provision. Applying the definition of non-prevailing adverse party, the court concluded that the department was not liable for fees because it was not a party that had failed to substantially change the agency action. Our case, we believe, is the same. This is not a case where UCF failed to change its own action. So it could not be a non-prevailing party under the guidance of the only case we found, Johnson versus Department of Corrections. Staying with subsection 22, there was also no competent substantial evidence to support a finding that UCF participated in the protest for an improper purpose. Improper purpose under the BOG regulation and under 125.95 means, among other things, participating in the protest primarily to harass, cause unnecessary delay, frivolous purpose, or needlessly increasing the cost of litigation.
You don't think that defending a extraordinarily flawed invitation to bid process caused unnecessarily delay or needlessly increase the cost of litigation? I mean, this I read the ALJ's order, which was accepted by the university. I mean, it's pretty damning. This was a terribly flawed process. I mean, one of the bidders was included in the whole thing, and yet UCF continued, even when the facts came out, UCF continued to defend the process.
Well, with respect, the initial points raised in the bid protest had nothing to do with Brian Hicksonbaugh's participation in a couple of meetings early in the ITM process. That was raised the evening before we had the hearing. And even then, and it's in the record, UCF's Department of Procurement Services believed that the process was fair, that Spectra, the winning bidder, had outscored Centerplate in all respects. So despite the last minute disclosure of that information as a basis for the protest, UCF maintains, despite that the order from the ALJ, that the process was fair. But they made the decision to live with the ALJ's findings, and they accepted the order. Now, the improper purpose is not, what happened before. It's how UCF conducted itself during the hearing. And it produced thousands of documents. It made witnesses available. It did everything it could to accommodate Centerplate's request. It was a short hearing. It was a day and a half. So they did they did everything in their power to make this proceeding not harassing, not delaying, not frivolous, and not needlessly increasing the cost of litigation. So that's what is important for determining, and did they do any of those things primarily to harass, delay? And no, they defended themselves in what they believed was an invalid bid protest, as is their right. They didn't invite the protest. They didn't file the protest. The improper purpose section is really meant to protect a protester or an intervener. That's where you get the unnecessary delay, increasing cost of litigation. In this case, as the record reflects, Centerplate's contract was over. Centerplate, whether the protest proceeded or not, Centerplate contract ended in summer of 2017. So they weren't delaying anything. They weren't increasing any costs for Centerplate. Their contract was over, and it was just a function of whether the university went on the Spectra or they went on with the direct support organizations contracting directly for these services, which is what happened. Frankly, it was UCF's position that Centerplate filed the protest so they could extend their concession contract through the football season. And with that, I see my time is up. I'll reserve and talk about the constitutionality when I get back. Thank you.
Good morning, Your Honor. Cindy Laquadera on behalf of Centerplate. I will take first the question raised by Judge Orfinger on the relationship of the certiorari proceeding. This UCF in this legal proceeding attempts to have it both ways, and neither of them make any legal sense or have any precedent. In each of their arguments, they're seeking to have this court distinguish itself by creating law far different from any other appellate court reviewing bid protest proceeding. In this situation, UCF was given the opportunity to create its own process rather than go through Chapter 120, which it did. Under 18.002.13, they created a process for appellate rights. In those appellate rights—
Did UCF create that process, or did the Board of Governors?
my apologies, Your Honor. The Board of Governors adopted that, and it applies to UCF as one of the universities. In the Board of Governors regulation 18.002, it provides for certiorari jurisdiction for challenges to the final order. That's in the reference to 9.9130B3. It's a cert appeal. So when a final order came out from the president, despite the express language of 22, which says it's a quasi-judicial officer, the proper method for us to have attacked that was certiorari, which we did, and in which there is a ruling. Now, there is a response to that. All the legal issues in this proceeding could have been raised in that. They were not. There could have been an appeal if the decision did not address issues that UCF wanted them to do. We all know second tier. I'm so sorry.
Right.
Someone must have opened that door.
We all live in fear of that happening.
I'm so sorry. I thought I'd locked it because yesterday, Your Honor, the cat ran in with the snake, and that would not have been a pretty scene for anyone. So my sincere apologies. I really thought I had closed that door. But under 18.002.13, the appellate rights that the university would have is by cert. And they have the benefit of substantial competent evidence. The court looked at that, and there could have been an appeal. And while we all have had second tier cert appeals, we know they're narrow on the issues of law. There's certainly the judges all do their jobs quite well and address the issues of law.
Is there any other proceeding that you can think of where the ALJ issues a final order and not the, I'll call it the agency opposing counsel, probably doesn't agree with that, but let's just say the agency doesn't issue the final order itself.
Yes, Your Honor, and the cases cited in our answer brief include those with the Department of HRS. I always get the proper names wrong. There's a case that I can cite to you in just 1 second on that. And because in fact, it is usually the case that the agency is not the one because of under 120 and because of administrative procedure. It's typically the answers, the recommended order on the findings go back to the agency. But the courts have recognized, and indeed the rules have recognized, and it's inappropriate for that agency to also decide whether they should pay fees. And so the case cited, there's a nice discussion of it in Department of Children and Family Services versus DH at 781 South 2nd 511. And in that, of course, the DCF, in fact, conceded, as they must, that no, they really didn't have power to enter that order on fees. It lies with a quasi-judicial officer. So in following this, this process, the Board of Governors was not an outlier. They were, in fact, following the body of established law. In fact, we can't find, or there are no cases cited, in which an agency did pass on the attorney's fees imposed against it. And there's an opinion from the first DCA cited in here, because as you know, they have a lot of administrative law opinions. There's an opinion from the first DCA that says, of course, we recognize that it would be inappropriate. So the Board of Governors recognized that when it created paragraph 22. And it is important, we're lawyers, all the words matter. The Johnson case is not on point at all. The Board of Governors did not put adverse. They did not add the additional language that said that they have to change an anticipated outcome. And when one looks at the word and gives the clear language to each, in 22, the provision states that the non-prevailing party, those are not unique and odd words and difficult for lawyers and courts.
Counsel,
Yes.
is your kind of argument here that we should not really consider 120.595 at all in interpreting this subsection 22 of the BOG procedures?
No, Your Honor, there are sections of 120.595 that don't have the word adverse in them. Those are in some of the cases cited. The particular Johnson case cites and has adverse and has this broader definition of what the issue is in defining adverse. So those are just not inapplicable. But the clear language, and as the court is well aware, that when the language is clear, you just apply the words as they say. They say non-prevailing party when they want to refer to the protester in that same one paragraph, they use the word protester. When they want to refer to the university in that same paragraph, they use the word university. And so, for example, it says, if the fee award is against the protester, then don't give the protester their bid bond or their protest bond money back until the protester pays the fees. So they've thought of that. They've looked at and genuinely wanted it to apply to the basic understanding of non-prevailing party. Now, turning to improper purpose, the administrative law judge incorporated the recommended order findings, which of course referenced incorporated testimony, in addition to issuing a very detailed recommended order. And in that detailed recommended order, noted that yes, thousands and thousands of pages of documents were produced to us in which we had to look and find this behavior. The behavior known to UCF all the time and unsustainable, grossly inappropriate. There were audio files. The testimony in the transcript shows we had to listen, transcribe, and submit audio files in order to find the procurement employee who testified that the procurement department had told them they can't do what they're doing, and was very concerned and told them that that was a problem under the ITN. So telling us to go fish on a process that they know cannot in any legal manner be sustained, and causing us to spend all that time and money while granting a contract to Spectra. And we'll note this is quite an unusual bid protest where Spectra, with $30 million at risk, doesn't even intervene. I think that's an inference, but regardless, the recommended attorney's fee order makes specific findings. Substantial competent evidence is the standard, not whether one of us could disagree. And under substantial competent evidence, as each of your honors are well aware, the standard is whether there is evidence that a reasonable person would take that is competent to support the decision. It's not a de novo look at the information below. There was one expert. There's no criticism of opposing counsel on that because I don't think could have found anybody. So the fees as specified were relevant. There are citations to the transcript in which he talked about looking in that market and as well as the unique market for bid protest, and a reference to how very old I am in terms of the experience I have in handling such matters. So there is no contrary evidence really because there could not be, and he made the findings along each of those 8 counts. So we would say that he applied the term improper purpose. It includes in the definition by the Board of Governors, it includes frivolous. It clearly had no defense. There were 4 separate grounds. And as to the last minute raising of a specific issue, the pleadings in the record are broad enough to address it. And the discovery goes on as the court found right up until the time of hearing, in which we had to ferret out the known bad behavior of UCF. So we filed a petition for cert.
But Centerplate in this case, Centerplate is the one that brought the bid protest proceeding. UCF didn't bring the proceeding. Are you saying they can't make Centerplate prove its case? They don't have the right to defend it, even if they think they might lose? That's frivolous?
Oh, of course not. No, Your Honor. And thank you for giving me the chance to clarify. The facts on this case show that they had no possible defense. That their own procurement people said, no, it violates the ITN. That's a testimony. Those are the citations that's in the transcript that we had to find for listening to audio files. They knew because they worked with Spectra to draft the ITN. And when its rules say you can't do it, they knew because they met with Spectra privately and their rules that they're implementing say they can't do it. So this is not like most bid protests, some that I have pending right now, where the question is, were the decisions made so arbitrary as to say that the subjective calls made were improper? That's not this case. This case is UCF from day one knew, had control of all the information. If one looks at the transcript, the opening from UCF is saying we're going to have fees, but they never identified any basis for upholding their decision ever. The rule under Rule 13 gives them a process for meeting with us ahead of time, for going through any of that. But none of it was gone. We had to find it. That's what the court found, all that discovery.
Well, some of the stuff UCF did, they may have been up to shenanigans early on in the ITN process, but where is their improper purpose in choosing to participate in the proceeding? It needs to be related to their participation in the protest. How was that improper?
The court's findings on that, which are supported both in the transcript and in the recommended order on paragraphs 4 and I believe then 7 through 14, identify the great discovery dump, the amount of work done, the fact that during the protest hearing that's used to extend payment to Spectra and give them a contract for which they were not entitled. That's all substantial competent evidence. So this is not a case. If this is not the case, I'm not sure what case would be where UCF or where a university could be found to have an improper purpose.
You call those thousands of pages a discovery dump. Was that unsolicited or was that in response to your request, your
Well,
discovery?
Your Honor, nobody asked for 10,000 pages. We asked for information pertinent to a protest. And so I'll leave it to the court's experience and the findings of the court in the record and in the transcript during the hearing and in their findings.
From the pretrial statement, at least 12 fairly complicated issues that the parties agreed the ALJ had to resolve through the hearing. Again, how is it improper to then request the ALJ to sit there and let the ALJ make those decisions? That's an improper.
Yes, Your Honor, it is improper as the university to publish an ITN for all of their key witnesses to know that from day one, they violated numerous sections of that. And instead of just rejecting all bids, saying, once we call them on it, hey, that's not right. You're doing something we raised earlier. You're doing something wrong with Spectra. That's all we had to say. We had to say the word Spectra. Spectra's like, I'm not making eye contact. They don't participate. And UCF goes on a lengthy process in which we had to ferret out from thousands of documents this bad behavior that they knew, that we called the procurement person. And we asked them and they're like, no, we shouldn't have done that. No, we told them we shouldn't have done that. Your Honor, the findings support substantial, competent evidence that this was done for an improper purpose, for a frivolous purpose, that it caused excessive and that UCF knew it. If not now, then when? Is the defense improper? It really is. We've been at this now for years, just trying to get them to do the right thing.
Let's talk about another word in 22, that if there is an improper purpose, it still has to be primarily to harass or cause delay. You think that's the primary reason that they wanted to defend themselves, was to harass you, your client?
Your Honor, when one reads 22, it's not primarily to harass, and then separate words defining harass. It's harass, comma, and it continues and includes before the semicolon, frivolous purpose. And this is a frivolous purpose. They knew they had no defense. They just ran up the cost, hope we didn't find it, hope it's too expensive for us to continue with it. But this was just wrong. It was just wrong. And so the frivolous purpose findings are incorporated into this recommended order. Improper purpose, yes. They did find improper purpose to cover up known misdeeds. That can never be proper, covering up known misdeeds. Not errors of judgment, intentional known misdeeds. That's what is supported by substantial competent evidence. I see I've got a few more minutes, so I will tackle a few of
Let me
the
ask a question about we haven't heard the constitutionality argument, but I anticipate it's coming. So I want to ask you a couple of questions about it. It seems a bit odd that the UCF, which arguably is subservient to the Board of Governors, can challenge the constitutionality of one of the Board of Governors regulations, and particularly without even letting the Board of Governors know, joining them as a party, as you'd have to do in a civil action. I mean, I can't imagine writing an opinion that says, oh, by the way, Board of Governors, your regulation's unconstitutional, even though you didn't have a hand in defending it. Do they have standing to even raise the constitutionality of that?
Your Honor, they may have standing to raise the constitutionality. I have to say, when I reviewed all of the cases, I didn't find it as clear as I wanted to be. The question is, whether that decision by this court could then be impugned by a separate action by the Board of Governors. So whether this court, when you have other legal methods of addressing the issue, whether you should engage on a constitutional matter.
Well,
And
no, I
think-
certainly agree that if we can resolve the case without a constitutional challenge, we should. But assume that that's the only basis that we get down to. I mean, the Board of Governors hasn't been involved in this proceeding, and it seems a little odd that they might get an opinion that says, oh, by the way, your rule is unconstitutional when they weren't a participant.
Yes, Your Honor, and to the extent they do have authority, which I have to be candid and say, I just do not see it as a subservient agency, but didn't have any case law on that specific point. So I would say, number one, no, they don't. But second, it creates an act of futility for this court because it can't be binding under Florida's established rules on claim and issue preclusion or collateral estoppel. It cannot be binding on a party that has had no role and ability to participate in it. So besides the fact that these issues should all have been decided by cert, that issue is not properly in front of this court for final disposition of the case. So I would say no, they don't have authority as subservient. Second, even if they did have authority, it would be a futile act by this court or a temporary act because it doesn't apply to the parties. And you would have every other university out there saying, well, it didn't apply to me.
All right, counsel, well, thank you for your argument. You've
Thank you.
exhausted. All right, Mr. Crosby, you've got just under 5 minutes.
Thank you. I'd like to just briefly address a few points that Ms. Laquadera brought up. The fee order talks about improper purpose, I think in 3 paragraphs, or maybe 4, maybe 1, 3, 4, and 31. Without exception, except for the DSO contract, it's generalizations about what happened pre-protest. Nowhere, to my recollection, does the quasi-judicial officer say that UCF participated primarily for an enumerated improper purpose. As to fairness of the proceeding, Mr. Hicksonbaugh, who was employed by Spectra, was also in a management role at the UCF arena. He was included early, and this is in the record, early in the ITN formation stage because of that role. When procurement services found out about it, they said he can't do that anymore. That's the reason he was in there. And as a result, the testimony is, the testimony under oath from procurement services and from the people who were involved in the analysis of the bids was that the process was fair. That's the testimony under oath. Now, that it was not, oh, we messed up and we should have rejected everything. That was not the testimony. That's not what the record reflects. And now let me turn to the constitutionality argument. And I respect the question about whether the Board of Governors needs to be joined. I'm not a constitutional expert, but I know we cited in our reply a criminal case where there was a statute that the court determined was unconstitutional. And in that case, the legislature was not joined, and the legislature did not have an opportunity. So I don't.
But the statute specifically says the state has to be made a party, and the state attorney is one of the ones. The attorney general or the state attorney by statute is charged with defending the constitutionality of statutes. So in a criminal case, the state would already be a party.
But there's not a corollary that I'm aware of for the Board of Governors to be
Well,
made.
there's a rule of civil procedure, and there's a something in Chapter 86 that says if you want to challenge the constitutionality of the statute, you've got to join the state attorney or AG. But I agree. I don't know of anything in administrative law that says that. It just seems odd to me that a subservient agency, and B, you could get an order that says it's unconstitutional without inviting them to participate.
Understood. But and back to our position, it is, in our view, facially unconstitutional. The Board of Governors took power from the legislature that they were not granted because attorney fee provisions are substantive law, and that's within the aegis of the legislature. And you know, Florida Patients Compensation Fund versus Roe and a number of other cases are clear on that. Article 9, the amendment to Article 9 of the Constitution gave considerable power to the Board of Governors, but it didn't give them everything. And that was the Graham versus Herodopoulos case. It
But
didn't.
isn't there an established method for challenging a rule?
Under,
Isn't there an established method for anybody who's an interested party to challenge an agency rule?
well, neither the Board of Governors or UCF is an agency, so there's not an established rule for universities or for the Board of Governors. And so we're entitled to raise constitutionality in this matter because the quasi-judicial officer had no authority. You know, we could have retained an attorney with 5 years experience, but there would be no basis for that attorney to rule in the underlying case that provision was unconstitutional. So we're entitled to raise it now, and it is, unfortunately, an unconstitutional usurpation of the legislature's authority to create a prevailing or quasi-prevailing attorney fee provision. And so that's why we're raising it now. If the court can resolve this in our favor without getting that, then of course the court shouldn't do that. But if you've been unpersuaded by our arguments on the fee order, then the court should declare that Section 22 is unconstitutional. It's an encroachment on the authority of the legislature. Thank you all.
Thank you all. That'll conclude this argument, and we'll reconvene at 10 o'clock for our next case. Thank you so much.
Thank you.
Thank you. Thank you.